So this video and recording is in relation to All States Frozen Foods Pty Ltd and the Federal Commission of Taxation in the 1990s. There was a case between these two, and it was around the ownership and the court's consideration of stock that has been purchased but not yet received, whether it should be classed as trading stock for the relevant taxation period. So this, in a way, is facts around the ownership and at which point does the ownership occur. So a little bit of business background for All States Frozen Foods, a food wholesaler that buys stock from various overseas countries, comes to Australia via sea container, by boat, and then is on-sold, obviously. So the main question here is stock in transit. Is stock in transit classed as trading stock, even though it hasn't been fully received by the customer or by the purchaser, more to the point. So ownership is considered to be transferred to All States Seafoods once documentation has occurred. So even if they haven't received it, that's what the case was all about, and the implementations of receiving the stock. So the legal issue here is stock purchased but not yet received by All States Frozen Foods classified as trading stock for taxation purposes? The decision, yes. The court found that yes, it should be classified as trading stock even if it wasn't in transit, since the owner was in full control from shipment, and it should be included in the taxation assessment for that year. So let's look at the implementation and application of the law. So under Section 25 of the Income Taxation Assessment Act, this outlines payments of goods that are considered assessable income for the year as they may be intended to be resold and not in capital nature, have to be included in your taxation assessment. So since these goods were frozen foods, it wasn't capital in nature. So this is where straight away the judge would have looked and gone, yes, this should have been implemented into their taxation. So one of the cases between Farnsworth and the Federal Commission of Taxation in 1949 was about a fruit grower. So whether the fruit ownership, once the fruit was delivered to the packing house, was still the owners, or whether it was still the farmers. So the judge looked at it was, once it was delivered, who had control over it. So it outlined that once it was delivered, the owner drove away, back to his farm. It was, the ownership now lies in the packing house. So this case outlined the possession issues and influences on the whole thing of goods that are counted as stock on hand. So it wouldn't be counted as stock on hand anymore for the grower, it would be counted as the packing house. The case between Benjamin Smith and Son and the Commission of Taxation in 1928 was in relation a little bit to our sea container scenario. This was to do with wheat and grain, and who had ownership of that grain once it was loaded onto the boat. So same principle, once it was loaded onto the boat, it was the purchaser's grain, and even though that the grain hadn't been delivered to the buyer, it was in fact owned by the purchaser. Tying this case to to our sea container case. Even though it wasn't a sea container of grain, it was they put it into a cargo hold. The judge sided with the commissioner and said yes, it had to be inputted into the taxable income of that year. Sutton Motors and the Federal Commission of Taxation, same kind of scenario. Car dealership, they were waiting on stock. They have purchased the stock comes on consignment, even though they pay only a certain amount until the consignment is sold. That amount is still classed as trading stock for that financial year, even if it turned you buy 6 cars on the 25th of June and they don't turn up until the 6th of July, it's still classed as trading stock, that part of a consignment on the, that financial year, not the following financial year. Herbert Island, Pty Ltd and the Federal Commission of Taxation in 1979. This was outlining raw materials that haven't been converted into final products. Same scenario, a little bit different accounting practice, but still same scenario. So the raw materials that is brought, whether it be, say we're buying planks of wood to make furniture. You brought 2 ton of planks of wood to make bed frames. That goes into your raw materials trading stock on hand. Once you turn it into whatever you're turning it into, then that gets transferred out of that category, but still into another category, which would still be trading stock, but not raw materials anymore. So in that scenario, they would have come back and gone, well, it's still classed as trading stock for that assessable period. Section 28 of the Income Taxation Act, Assessment Act of 1936, puts reference to ascertaining what business income is and how that evolves. So a little bit like Section 25 of the Income Taxation Assessment Act. Seeing this wasn't a capital purchase, they brought stock to resell. They knew they were reselling it, so this act, well, this section of the act would have outlined that they would have had to input that into stock on hand. So we can see now how the arguments for this matter that the commissioner would have had, he would have been able to argue these points from these relevant acts and relevant cases to the judge in this case, to, in a way, benefit his side of the story. So that all comes down to drawing on these cases to give the judge enough evidence to side with the commissioner's side, or if there was enough evidence, they would have sided with All States Frozen Foods. But on this case, the judge affirmed that despite the goods have not been received, they were in transit, there was enough documentation, so the documentation that was signed off on and agreed to on the purchase of this sea container of stock, that held sufficient evidence and sufficient evidence of ownership that All States Frozen Foods knew that they were buying this, and they knew that they had an intention to resell the product that was in the sea container. So this supported the Commission's view that it had to be included in the taxable income of a relevant year. So moving forward, like cases like this would emphasise when goods should be put into trading stock on hand, even while in transit. So, later on, another case may come up where the Federal Commissioner will also look at this one and go, hey, this is quite similar. we can use this case as evidence to prove why, even though they haven't received the stock, it should be included in their trading stock for the year. So this impacts how companies account for in transit stock and goods for their end of year tax calculations. So I hope this gives you enough insight on the reason why the judge went with the Commissioner's view and sided with the Commissioner, and gives you enough understanding of reason why, even though you haven't got the stock, if you've paid for it and you've had the documentation, then legally the stock is yours, whether you have it physically in hand or whether the stock is still arriving. Thank you for listening, and I do hope this is a little bit of insight on how transient stock is trading stock.